Ndị be anyị kenekwanụ m unu. Anyị sị ka ụbọchị nke taa mara na anyị na mma. Anyị sị ka nkwenye chikwelu ya ezelụkwa. Dịka o si dị, ụmụ Igbo ewetara unu ozi gbasara maka ya bụ ife na-eme n'obodo anyị nọ n'ime ya. And nwere owe a na-azụ n'ala Igbo. Ya bụ ife ka eji maka ya wee bịa n'iru akwụkwọ n'ụbọchị nke taa. Biko gee ntị ọfụma na ya bụ update anyị ji maka ya wee bịa na Eastern News 24 ebe anyị si na-ewetara ya bụ ozi. Ozi a bụ according to the Biafran activist wetara ya, and as he quote, breaking news. International media react to injustice against NNAMDI Kanu by the Nigerian government on the court of Federal High Court Abuja on 26th of September 2025. Hear the news in details. This news is according to the Biafran activist and what it really means to Ndi Igbo and to the whole Nigerians and to the whole world. Because onye ọbụla chọrọ Maazị Nnamdi Kanu trial bụ only the trial of Ndi Igbo. Mana gee ntị n'iru akwụkwọ ka unu nụrụ ihe ya bụ international media wetara n'ụbọchị nke taa. All right, over to you.
Now, and straight to the federal level, where the Federal High Court in Abuja has rescheduled its ruling on a no-case submission filed by NNAMDI Kanu, leader of the indigenous people of Biafra. Kanu, who faces terrorism charges and has been in detention since his controversial return from Kenya in June 2021, is seeking to have the case dismissed. Now, Justice James Omotosho fixed a new date after hearing arguments from both sides. Originally slated for 10th October, the ruling will now be delivered on 26th September, according to Kanu's lawyer, Aloy Ejimako. Joining us now to assess this no-case submission and perhaps chances for the IPOB leader is Barrister Chidi Uja-Atumba, CEO Uja-Atumba and Company. He's a human rights lawyer. Barrister Chidi, I almost called you Mr. Aloy.
Good morning and
Good morning, Barrister Chidi. Great to have you.
Good.
It's quite bright and sunny. I mean, you can see the sun cascading into the set.
Yesterday was something else.
Could be symbolic of brighter
days. It was
days.
bucketing like Noah's flood. No one could do anything.
So it's from raining to sunny, and this is big.
Yeah.
We have to establish that this is big. Some have seen the news. It's been. What this is saying essentially is that the judge is going to rule whether to dismiss this case and free Maazị Nnamdi Kanu, or to continue the trial if the no-case submission is in fact dismissed or it fails. Could you put this idea of a no-case submission in perspective? What does it mean? Okay,
before I do that, let me let you in on, I think something happened in August. Nnamdi Kanu's brother filed a 13-paragraph affidavit asking the vacation judge who was sitting during August. You know, during August, lawyers were on break, judges were on break, but there is always a vacation judge that sits during that vacation in case if a case comes up. So he filed a 14-paragraph affidavit asking I think that was Justice Lima of the Federal High Court, to release Nnamdi Kanu for medical treatment, that his health has deteriorated, he's facing heart problems and challenges. So the judge could not actually rule on that. What he did, that he transferred the matter to the general cost list, thereby making it go back to the judge who is handling Mr. Maazị Nnamdi Kanu's case. And based on that, the case was now rescheduled from 10th of October to 26th of September. And I think that the court will be hearing 2 applications tomorrow. The court will be ruling on the affidavit filed concerning Maazị Nnamdi Kanu's health challenges, and also the no-case submission that Maazị Nnamdi Kanu's lawyer brought when the prosecution closed their case. So these are the 2 things we are looking at tomorrow. Whether Maazị Nnamdi Kanu will be released to attend to himself health-wise, and also whether the no-case submission will discharge and acquit him. If we are on the same page, then I can proceed to delve into the nitty-gritties of a no-case submission.
So, regarding to the momentum at this point in time, yes, health on one side and no-case submission at the other side, which one is more relevant and that would take the order of the day tomorrow?
Okay, I think the issue of health should be attended to because of its expediency.
But not should. Which one would?
Which one
Which
would
one
take the
would?
order of the day?
Because the main headline is on the ruling on the no case submission. So based on the facts before us, which one would take priority? I mean, I highly doubt we can advise Justice Omotosho, right?
I don't know. I am not the judge. I don't know the one that the judge will attend to first. But Justice Lima, who referred the case of Mazi Nnamdi Kanu's health back to Justice Omotosho, who is handling the actual trial, wrote there that this is very, very urgent. And when we talk about case takes preeminence, I don't think Mazi Nnamdi Kanu's case the time was abridged because the no case submission ruling was ready. I think it was abridged because Mazi Nnamdi Kanu is going through health challenge. So based on this incident, I think the issue of health should be attended to first. It should be attended to first. But if the no case submission succeeds, so even after you have gone to attend to his health, okay, from there he can now proceed to his house and the case is over. So if we are okay to this extent, I can now go deep into what a no case submission is all about.
Okay, go ahead.
Okay, right. A no case submission is an application that is brought by a defendant after the prosecution must have called all their witnesses, tendered all their documentary evidence, laid to the face of the court everything that they have to prove their case beyond reasonable doubt. Now, when the prosecution have concluded to do that, the defense counsel will now analyze the veracity and the probative value of all those evidence one after the other. After that, they will now check to know whether the defense has a case to answer. It's always important. Does the defense have a case to answer? This is a paramount. If you are a criminal, if you're a lawyer and you're into criminal cases, you must always be able to possess the skill to know when the defense has a case to answer. Now, the lawyer for Mazi Nnamdi Kanu, after perusing through the processes and the evidence and all the allegations expounded by the prosecution, have now come out to say that Mazi Nnamdi Kanu has no case to answer. Okay, that's why they filed a no case submission. The no case submission is not filed in vacuum. Okay, it contains a blow-by-blow analysis of the prosecution's evidence. Now, if time can permit me, I will delve into one of those evidence and tell you why Justice Agabi filed a no case submission.
Go ahead, because we have to break everything down.
All right.
Slices.
All right. He brought 13 grounds upon which the no case submission was predicated upon. I will touch on anyone that my memory could lead me on. Now, I think the very first one is, he said that the statement made by the witnesses, the witnesses were actually covered because of security purposes. They were covered, only their names and their office, but you can't tell their face, you can't tell who they are. So they were covered. All the witnesses called by the prosecution, all the witnesses called by the federal government, none of them were able to answer a direct question. If you ask them a direct question upon how they obtained their evidence, they'll tell you either I don't know or I was not there. So what it means is that they tendered a statement without proper investigation. All the allegations, none of them were investigated. So this is one of the grounds upon which the no case submission was filed. There's also what we call probative value. Okay, any document you are tendering in a court of law, before that document must have a weight, you understand, to give you a win or a loss. It must have what we call probative value. Probative value is what we call weight. Does it have weight? Does it prove anything? Does it contain the substance of justice? Okay, if it does not contain any substance of justice, it lacks no probative value. So Agabi is also saying that all their evidence and all their witnesses lacks no probative value. Now, third, he said that no person was presented in the court who the federal government can say was incited by Mazi Nnamdi Kanu. No person, no name was mentioned. Not in the north, not in the south, nowhere in Nigeria did the federal government present somebody a physical living being who can say, I was incited by Mazi Nnamdi Kanu broadcast, by Mazi Nnamdi Kanu's statement, or anything done by Mazi Nnamdi Kanu. So these are some of those ones. He went further to say that the prescription of the organization called IPOB, okay, the Federal Ministry of Justice filed a gazette where IPOB was prescribed, okay, outlawing IPOB. That very gazette lack presidential approval. The president never approved it. There should be a document approving IPOB. So he said that it was not approved. Okay. Now, when you come to the other side, you find out that when they filed the first charge against NNAMDI Kanu, they also amended that charge and filed a subsequent one. That subsequent one upon which NNAMDI Kanu took his plea. You know when what do you mean taking a plea? Are you guilty or not guilty? Not guilty or guilty. That very charge was not filed before the honorable court, and they went ahead and predicated and based on their trial, based on the charge sheet that was not filed before the court. The lawyer for NNAMDI Kanu also went ahead to state that what NNAMDI Kanu did was to ask his people, the Southeasterners, the Igbos, to defend themselves because of the invasion of the Fulani headsmen and the terrorists. That was all he did. And he went ahead to play a video in court where the former head of state, the former head of state during the time of Gowon. You know when, not Gowon, there was this former head of state that was asking Nigerians to defend themselves. And also the former, the current police head was on air asking Nigerians to take up arms and defend themselves because of insecurity. So he also said that T.Y. Danjuma told Nigerians to defend themselves, and also the current IGP told Nigerians also to defend themselves. Last but not the least, they tendered NSAS report. You understand that it was NNAMDI Kanu that incited NSAS. But when they came to court, they were unable to link any activity of NSAS to NNAMDI Kanu. So the whole report of NSAS, which they tendered against NNAMDI Kanu, is so laughable. So these are the few points on that 13 points that Agabi listed that predicated him to file a no case submission, because a no case submission simply means that this man has no case to answer.
Excellent analysis, Barrister Chidi. You've hammered on those points and greatly established. So let's look at special considerations in this case. In terms of statistics, looking at Nigeria, and of course you being in the practice, how many events have you seen success in no case submissions? And looking at the context around NNAMDI Kanu's trial, he's being faced with terrorism charges and those of treasonable felony. Looking at the context, what are the chances of this no case submission being given the pass mark by the judge?
The chances outweighs every other possibility that I can fathom, you understand, within the ambit of my legal resources. It's crystal clear. It's undoubtable. You cannot do otherwise. Okay, when you are faced with issue of law, you itemize the law that concerns those issues and give it the way that it requires. When you face an issue of politics or sentiment, that's an entirely different thing. When you legally look at the case of NNAMDI Kanu, you will agree with me that no case submission, in the eyes of law, you understand, should go through the day, as in it should get the assent of the judge. The judge should approve, or rather rule positively on behalf of NNAMDI Kanu for that no case submission, except if you have not availed yourself of the opportunity to study the case of the prosecution. That's the case of the federal government. If you have looked at their case, if you have looked at the strength of their case, one after the other, with decided cases, I personally have been opportune to win a case based on no case submission. I base everything on probative value. If the witnesses and the evidence of the prosecution lacks no probative value, no judge can go ahead and rule against that probative value and ask the defendant to enter inside the witness box and defend himself. It's not done. You have to rule on that no case submission, it always comes with discharge and acquittal.
In simple terms, because people cannot move blindlessly in hope, especially those who support this leader of IPOB. Statistically speaking, in your years of practice, in your studies, how many times have we achieved success in no case submissions in the Nigerian judicial system? Because we can't just hold on to hope at a whim. Those who actually do want him to be released. Could you give us some kind of figure? How frequent does this hold water?
It holds water. I think no case submission has come to stay. It holds water, both in the magistrate court, which is a lower court of trial, and also in the federal high court, and also in the state high court. No case submission always hold water. Let me tell you, let me tell you one thing about law. Law is all about evidence, okay? And if you don't have the right evidence to prove your case, okay, if you look at the mother justice that closes its eyes, holding a scale on one hand and holding a sword on the other hand, you know what it means? It means that when you are making a point, that point you are making should make the scale tilt towards your own side. It's a weight. It carries weight. Evidence carries weight, okay? That's what we call the burden of proof. It carries weight. So when you are making that burden, when you are discharging that burden legally and justifiably, the weight will be added to you. So in this case now, we are not seeing any weight being added to the evidence and the allegations of the federal government. So on a scale of 1 to 10, okay? 1 being the evidence of the prosecution and the federal government, and 10 being the no case submission filed by the counsel to NNAMDI Kanu. I think we are looking at maybe on the verge of between 8 and 9, and that's a very positive and a powerful point.
In the case where a no case submission is ruled in its favor, when it actually achieves success, the prosecution can decide if it wants to appeal such a judgment. Do you see the federal government, who is the prosecutor in this place, going ahead to appeal the verdict if they rule in favor of NNAMDI Kanu?
Yes, if the no case submission is in favor of NNAMDI Kanu, the no case submission will apply. Okay, NNAMDI Kanu will no longer be in detention. The no case submission will fully apply to its last alphabet. NNAMDI Kanu will be discharged and acquitted. He will go back to his house. The federal government cannot appeal against the judgment of the Federal High Court. The federal government will appeal against the judgment of Federal High Court at the Court of Appeal. But while they are doing that, NNAMDI Kanu will regain his freedom, take care of himself, and now his lawyers will not go on appeal. His physical presence is not required during appeal. What they are appealing is they're appealing against the no case submission, which was ruled on by the Federal High Court judge.
But if you get this submission at the end of the day, right? Is there a room for him gaining his full freedom, but being rearrested on new charges? Instanta.
No. See, let me tell you something. They can't rearrest him on any new charges instanta. I wonder what would be the head. Why? Should I tell you why?
Out here is because if you look at this judgment, if you look at the process of all this war since 2021, you will know that FG never wanted NNAMDI Kanu out of that court or out of that DSS dungeon.
Because it's not just about a legal problem, it's also a political problem. It's a political issue. That was why I had conversed from the initial time. Can we settle this matter out of court? Okay? There are people who have done there are people who have done 10 times of what he's been alleged to have done. And they're going around.
We saw what happened in Castell.
Yes. Do you know that they are planning to stage a protest on the 1st of October against 10th of October, initially when the case was supposed to come up, okay? The placard is always out. The billboards are out. It's split into two. One is NNAMDI Kanu. The other one is all these terrorists in the north carrying guns who are sitting on the same table with federal government, negotiating with them on how to stop terrorizing the community. So look at it. Just look at it from one side. You find out that there should be a need for that kind of a protest. But what we are looking at now is that you can't rearrest him again after a no case submission have succeeded. You can't, okay? You can't. Once someone has been charged for an offense and he has been tried for an offense and he has been discharged for that offense and acquitted, you cannot charge him for that.
You say you can't, like I trying to speak, you can't into existence.
No, you can't. You can't. It's a law. It's a law.
It won't happen.
It's a law. It's a law.
Okay.
It's a law.
All right, we're out of time, but I mean, greatly put. I think now we've already engineered the minds of our viewers to understand the gravity of that court as an event tomorrow, if we can call it that, the ruling itself.
On no case submission.
Yes, Barrister Chidi, thank you so much for joining this morning show today. I know we could go on and on, but let's close the curtains for now.
It's okay.
And reopen them
and see what happens in court tomorrow.
Yes, I hope the sun shines this brightly.
It will.
It's quite symbolic. All right, and if you're just joining us, we've been discussing what is going to be the biggest news tomorrow as the Federal High Court in Abuja would rule on the no case submission filed by counsel to NNAMDI Kanu. So all eyes are going to be locked to the Federal High Court. The morning show returns in split seconds.
Ndị ba ngwadalo li nene dukun siwe ge ya bife wetelu n'ụbọchị uru tinketa. Anyị ga-anapụ n'ukwu nri ya tia gbasata maka ya bife ndị a niile ụmụnna wetela anyị. Gwa ifu nche n'udo nke unu. Ngwanụ ka emesịa n'ụmụnne m.